Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with an update regarding the Kamakhya temple in Guwahati. In 2017, the Guwahati High Court had directed the Deputy Commissioner to receive donations given by the devotees for the developmental activities in the temple and had asked to maintain a separate account regarding the same. Now, the Supreme Court has held this High Court order to be inoperative. Challenging the orders of the High Court, several petitions were filed in the Supreme Court. Before the top court, the state of Assam placed on record an affidavit appraising that a meeting took place in August this year to discuss the matters pertaining to Ma Kamakhya corridor. The same was presided over by the Chief Minister of Assam, and it was decided that at present the temple chief, that is, Doloi Samaj, is running the affairs of the temple administration satisfactorily in close coordination with the local administration, and the current system should continue. The court was also assured that the government of Assam is actively taking up the developmental activities of the temple under the PM Divine scheme. So the apex court recorded the assurances given by the state, and the bench comprising Justices Abhay S. Oak and Pankaj Mittal ordered that the High Court's order will not operate in view of the prevailing arrangement. The Delhi High Court has directed the union government to frame a policy to regulate online sale of drugs or medicines within 8 weeks. A division bench comprising of Acting Chief Justice Manmohan and Justice Mini Pushkarna was hearing a bunch of pleas seeking a ban on online sale of drugs. The plea contends that illegal sale of medicines on the internet could lead to drug abuse and misutilization of habit-forming and addictive drugs. The petitions also challenged the draft rules published by the Union Ministry of Health and Family Welfare and to further amend the drugs and cosmetics rules. While posting the matter to 4th March 2024, the court said that if the policy is not framed within the stipulated time, the concerned Joint Secretary dealing with the subject shall remain present in court on the next date of hearing. The next update is from the Calcutta High Court regarding alleged custodial death. The High Court today heard mentioning of a plea by an advocate alleging foul play in the custodial death of a young man who was called for questioning by the Kolkata police to Amrest Street Police Station. A division bench of Chief Justice T.S. Sivanganam and Justice Hirannamay Bhattacharya were told that within a few hours of the youth being called for questioning yesterday, his family was informed that he had passed away at the police station. The counsel told the court that the family wanted to see the CCTV footage of the police station, but the police had refused for the same. And they now insisted that the post-mortem be done under videography. Upon hearing the claims, the court directed for a formal petition to be filed before the registry in order for the bench to take up the matter tomorrow. Stay tuned for further updates. In another update, the Delhi High Court today issued notice on the petitions filed by Devangana Kalita, seeking certain videos of the CAA NRC protests and chats of WhatsApp groups of police officials in 2 Delhi riots cases against her, including the UAPA case alleging a larger conspiracy behind the violence. It is Kalita's case that the videos have been shot by someone commissioned by the Delhi police on the basis of a tender. Her counsel, advocate Ajit S. Pujari, submitted that the videos will demonstrate her innocence and also the fact that she was indulging in peaceful protests. Pujari submitted that the videos form part of the charge sheet filed by the Delhi police against Kalita in both the cases. It was further contended that the supply of videos was essential as Kalita wants to exercise her valuable right of getting discharged from the cases. On the other hand, Special Public Prosecutor Madhukar Pandey, representing the Delhi police, raised a preliminary objection on the maintainability of the petitions. He submitted that Kalita could not have approached the court under writ jurisdiction when there are other efficacious remedies available to her. Justice Amit Bansal issued notice on the petitions today. The Delhi High Court has been directed to file status report or reply to the petitions, and the matter has been listed for further hearing on 17th January 2024. With respect to the Narcotic Drugs and Psychotropic Substances Act, the Supreme Court has held that the law does not require only an independent witness to prove a charge attracting the provisions of NDPS Act. A bench of Justice M.M. Sundaresh and Justice Arvind Kumar made the observation while considering a case where the appellant had been found guilty of an offence under the Act by the trial court and subsequently by the High Court for possession of 54 kgs of poppy husk. The appellant argued that only police witnesses had been examined, and in the absence of any independent witness, he should not have been convicted. It was also argued that the appellant was merely traveling in the car, that he was not in conscious possession of the contraband, and that the procedure contemplated under the NDPS Act with respect to seizure and recovery had not been complied with. The apex court did not agree with any of the contentions raised by the appellant and hence refused to interfere with the High Court order. The court held that law does not require only an independent witness to prove a charge attracting the provisions of NDPS Act. And the courts below rightly held that procedural compliance with respect to arrest, seizure, and recovery was done. The Supreme Court has reiterated that eligibility criteria for a post as set out in the rules cannot be relaxed unless the said relaxation was envisioned in the rules for advertisements for the post. Further, in case of any such relaxation passed, the same must have been widely publicized to be held valid. A bench of Justice Rishikesh Roy and Justice Manoj Mishra was dealing with the batch of appeals concerning recruitment on the post of Junior Office Assistant, that is JOA, under the government of Himachal Pradesh. A judgment of High Court of Himachal Pradesh was challenged, which upheld state government's action of relaxing essential eligibility qualifications required for the post as per the recruitment rules after last date for receiving applications from the candidates. The High Court had noted that the original rules, which had set the essential eligibility qualifications, were unclear and ambiguous. Therefore, the state government's relaxation order was valid. The result of this judgment of the High Court was that the candidates who were initially held as ineligible under the original rules were to be treated eligible as per the relaxation order, and the merit list was to be redrawn accordingly. This also meant that the candidates who were although lower on merit but otherwise eligible as per the original rules were ousted from the merit list. The Supreme Court underlined its earlier precedents to reiterate that the eligibility criteria, unless provided otherwise in the extant rules or the advertisement, must be fulfilled by the candidates by the last date for receipt of applications specified in the advertisement. The court added that the law was settled that if rules provide for the power to relax the eligibility criteria, the same could be exercised only if such power was reserved in the advertisement. And when such power is exercised, there must be wide publicity of its exercise so that persons who are likely to benefit by exercise of such power may get opportunity to apply and compete, stating that in this case it was not shown that the advertisement reserved the power to relax the essential eligibility qualifications specified in the advertisement at any later stage, and that the decision to relax the eligibility criteria was not widely publicized. The court held that the state was wrong. And lastly, the Madras High Court has granted bail to a man accused under the Unlawful Activities Prevention Act. While granting the bail, the High Court observed that merely threatening a person by claiming to be associated with an ISIS terrorist will not be a ground to hold that the person was supporting the terrorist organization. The court added that though such threats would be an offense, it was not an offense under UAPA. The court was hearing an appeal preferred by one Mohammad Irfan challenging denial of bail. Irfan, along with others, was found in a car intercepted by the police on the information that it was carrying arms and weapons. Subsequently, the NIA was entrusted with the investigation and the case was registered for offences under IPC and the Arms Act. The government also accorded sanction to prosecute the accused for offences under the UAPA. While opposing the bail, the prosecution submitted that as per the witness statements, Irfan had threatened some witnesses by claiming that his leader, the prime accused in the case, and others were ISIS terrorists and also threatened to kill the witness. The bench of Justice S.S. Sundar and Justice Sundar Mohan observed that the materials produced by the prosecution did not show any intention to support the terrorist organization, but only showed that Irfan had handled the funds for the prime accused, which was different than supporting a terrorist organization. The court added that for bail, while alleging conspiracy under the UAPA Act, it was necessary to show exactly what the terrorist act was agreed to be committed. While discussing the restrictions under UAPA, the court also noted that the restriction only meant that the courts cannot grant bail on mere asking and that there must be reasons for granting bail. The restrictions could not be read to mean that the basic human rights or the constitutional rights were taken away. I hope you found this video informative and enjoyable. If you did, please consider giving it a thumbs up and sharing it with your friends. Don't forget to subscribe and hit that notification bell so you won't miss any of our future content. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.